Pankana Ian Anderson, Palawachuana, Palmarana, Trawalawe, Plamamarana, University of Melbourne. Kantumada Mine, Warandri, Tiana, Kanamina, Nena, Nika, Nena. My name's Ian Anderson. I'm the Pro-Vice Chancellor Engagement at the University of Melbourne. And what I did was speak in Palawakani, which is the traditional language of my mother's people, to honour the Wurundjeri people of this place. It's a protocol of Aboriginal peoples to pay respects to the custodians of place, and this, in this case, is the Wurundjeri people of the Kulin Nation. And I do so on behalf of Mum's people, whose traditional country is Larapana, in an island we call Trawana, or otherwise known as Tasmania. I honour the Wurundjeri ancestors and their Narragansett and their clan elders. I also pay respect to the Aboriginal peoples of the country of Naarm, or Port Phillip Bay, the Boonwurrung, who share the country of the Birrarung, the Yarra River, the Wadawurrung, who are from beyond the Werribee River, the Djadjawurrung and the Tangawurrung peoples of central Victoria, the Wurrung people being people who name the country through language of the Greater Kulin Nation. I acknowledge our elders and our community. On behalf of the University of Melbourne, I'm delighted to welcome you all to the 2014 Human Rights Lecture. The lecture has a history going back to 2002 when the former Prime Minister of Ireland, Mary Robinson, delivered the first Chancellor's Human Rights Lecture. The lecture was established in the year to recognise the great contribution of a former University of Melbourne Chancellor, Faye Miles. As well as Chancellor, Faye served as Victoria's first Commissioner for Opportunity and was Chair of the University's Indigenous Education Committee, in fact, a wonderful benefactor of many of the Indigenous academics in this institution today. Her commitment to equal opportunity and human rights is legendary. Over the years, many distinguished Australian and international figures have delivered the Human Rights Lecture, including Justice Michael Kirby of the High Court of Australia, Dr. Kiran Martin, the founder of the Indian NGO ASHA, and former Prime Minister Malcolm Fraser. And tonight we are very delighted to have another Australian public leader and indeed a former University of Melbourne law academic join these distinguished ranks. Emeritus Professor Julian Triggs is the President of the Australian Human Rights Commission and the former Dean of the Faculty of Law at the University of Sydney. Professor Triggs has combined her academic career with international commercial legal practice. She has also worked extensively with government and international organisations on legal and human rights issues. In tonight's lecture, Professor Triggs will share her insights on Australia's approach to human rights protection throughout the history and into the present day. The title of her lecture, Australian Exceptionalism, International Human Rights and Australian Law. To deliver the 2014 Human Rights Lecture, please welcome now Professor Gillian Triggs.
Thank you very much, Professor Anderson, for your welcome. And it's a great pleasure, of course, for me to have been invited back to the University of Melbourne, to an institution to which I owe so very much. I was a student at University High School just across the road, and it was, of course, expected that I should come to this university. And it's been my home, spiritually and otherwise, pretty well ever since I first walked into these grounds on a very hot summer's day to the old law school quadrangle with the camellia bushes and that lovely old law library, where, if I remember correctly, I was interested to know that the topic of conversation was the cricket scores and not the most recent High Court decisions. And of course, in this university precinct, it's especially appropriate for me to acknowledge the traditional owners of the land, the Wurundjeri people, and to pay my respects to their elders past and present. Well, I was very honoured to receive the invitation to give the lecture this year. But I thought I would also perhaps tell you a little bit about my personal experience in the position that I've had as a recent advocate for human rights and social justice. And thinking about what that topic might be, it seemed to me that it could be coffee, croissants and the Bolt Report. For some Sundays ago, I was enjoying the Sydney sunshine where I now live, because that's where the Human Rights Commission is, having breakfast with my husband, feeling slightly irritated that Alan had put on Channel 10 and the Bolt Report, which he's, for some inexplicable reason, absolutely devoted. And I unexpectedly heard my name mentioned, and with transfixed horror watched as the next few minutes were devoted exclusively to calling for my resignation and the abolition of the Australian Human Rights Commission. This was followed the following day by various blogs from Mr. Bolt and editorials in The Australian, also demanding my head and the end to the 30-year-old Human Rights Commission. Well, how did it come to this, I wondered, in these what should have been my autumnal days of my over 45 years of tranquil and rewarding career? I should be smelling the roses, being a respectable middle-aged woman playing with my at least hypothetical grandchildren, writing another edition of my doorstop text on international law, or better still, teaching law at a university. And it is, of course, a long story, and I won't go into it in any detail except to say that one of my first jobs when I left the University of Melbourne in about 68, 69, having finished my law degree here, was with the Dallas Police Department. And people often remark on this when they look at my CV, but it was actually true that as a 28-year-old, I was hired in 1972 to help the Chief of Police implement the 1964 civil rights legislation, which was predominantly designed to ensure a non-discriminatory employment practices in the public service. Now, you might ask how on earth I ever got that job, and it was really because I'd been a summer intern doing my master's in Texas, and the Chief of Police realised that I was the only person prepared to give him federal advice on the civil rights legislation, because that advice was not available from the district attorney. Well, these were very exciting times. There was a real sense of possible change. But as it turned out, not in Texas. For one lesson I learned was that passing legislation, the civil rights legislation, was one thing, but giving effect to it in local law was quite another. And that lesson, the need to bring or achieve a cultural change for the community to agree with those amendments, is of immense value and, in fact, vital value. And that is a lesson that is, of course, relevant in my current job. I've been able to combine academic law with international commercial law, but I've also been married to a diplomat, and I've been a trailing spouse for some years, or as the author Lawrence Durrell remarked, I was diplomatic baggage, but with a ringside seat at some of the most fascinating issues of concern for a public international lawyer like me, including the nuclear tests by France in the Pacific. Or for some years, directing the British Institute for International Law, I returned to Australia as Dean of the Sydney Law School, and that, as my colleague Carolyn, as the Dean here will know, prepares you for just about anything else life chooses to throw at you. But when I was offered the position with the Australian Human Rights Commission, I frankly had no idea of the world I'd be stepping into. One aspect of the role that I'd not fully understood was the privilege of working at the national level. It's been an honour to travel around Australia and to represent the Commission at United Nations meetings on a wide range of issues. I've travelled by road with our Aboriginal Torres Strait Islander Commissioner, Mick Gooder, some of you may know, out to Katherine, and then on 2 or 3 hour trips in a 4-wheel drive up yellow, dusty roads to aged care facilities for Aboriginal Australians. I've been to work with migrant workers in Parramatta, with Islamic academic groups in Auburn, to visit asylum seekers and refugees in the detention camps throughout Australia, and of course on Christmas Island, where I've been 3 times. I've also had meetings with senior members of our military about gender issues that have been quite an eye-opener in terms of absolutely core human rights freedoms. But my topic tonight is Australian exceptionalism and human rights. And I'd like to explain what I mean by that exceptionalism, and to consider 3 relatively recent decisions of the High Court, before moving on to say a little bit about the inquiry into children in immigration detention. But to begin, historically, Australia has had a strong social justice vision, but that vision and leadership is, in my view, missing today, where decisions are all too often made for short-term political gain or to reflect the opinion polls in marginal seats. Australia has adopted a unique approach to protecting human rights that, while generally effective, is now fracturing in response to national security threats, asylum seeker refugees, Aboriginal Torres Strait Islander constitutional recognition, violence against women, and the special vulnerability of children. Of particular concern is the growing use of executive discretion without safeguards such as supervision by the courts or by other independent and autonomous bodies. The use and sometimes abuse of these executive powers arises in all sorts of contexts. Administrative detention of those unfit to plead to criminal charges on the grounds of mental illness, the 6,000 asylum seeker refugees currently held under mandatory closed detention in Australia, Papua New Guinea and Nauru, and the effective suspension of habeas corpus for those refugees adjudged to be a security risk by ASIO, the introduction of new anti-terrorism laws, and indeed even the new state bikie laws. Australia has become like a compass that's lost its due north. We have no benchmarks for understanding human rights, and the community is readily swayed by the latest concerns of fear and anxiety. But I thought we might perhaps begin by looking at the first, just one slide. This was in the Daily Telegraph in Sydney this morning, and it shows our Minister for Immigration doing an imitation of Russell Crowe in Masters and Commanders, a great movie. But you can see the language here, how the war on boats was won, and we have a victory at sea because 12 boats have been turned around, 45 have been stopped from leaving port, and 1,673 asylum seekers have been sent back to where they came from. And then we see the pictures of the boats and a little more detail about what the Daily Telegraph describes as the cloak and dagger maritime operations that have secretly turned back asylum seeker boats. Now, I thought we can take that one down, actually, but I thought it would give you some sense of what the public debate is and how the public is being swayed. Now, I know that in Melbourne, you are much more measured, you are evidence-based in your judgments, and you don't have a newspaper like the Daily Telegraph, but that newspaper is the paper which really commands huge attention in Sydney and in the western suburbs in particular. But what worries me about it is the complete absence of understanding of what the law requires, most particularly international law, but also Australian law and the common law. The assumption is that these numbers are numbers of which we can be proud, they constitute a victory, and they completely ignore the legal standards. And it's for that reason, in part, that I say that we appear to have lost our compass, we appear to have lost that set of benchmarks that most countries have. And I thought I'd illustrate it by what's called the freedom wars. Over the last year or so, we've had an unprecedented national debate termed the Freedom Wars, prompted by a coalition promise before the election or during the election to amend 18C of the Racial Discrimination Act, legislation that the Australian Human Rights Commission administers through our complaints process. And we receive about 20,000 complaints a year. We conciliate about 70% of them. One or two concern freedom of speech, hundreds concern racial abuse in the public arena. But the key idea put forward by what then became the government was the need to protect and promote the freedom of speech and to restrict the overreach, allegedly, of the current law prohibiting racial abuse. Well, a few weeks ago, we learned that the proposed amendments to 18C will now not proceed. I welcome and respect the decision by the Prime Minister. The decision not to amend 18C is consistent with the submission we made at the Commission to the government on the exposure draft, And perhaps more importantly, it responds to the overwhelming rejection of the proposed amendments by the Australian community. To the extent, of course, that we are allowed to know what they are. There were 5,500 submissions to government on the Racial Discrimination Act, but none of them was made public. Now, in Australia, of course, that's a rather foolish thing to do, because the Monash Human Rights Law Centre found out a very high number of those that had made submissions to the government and put them up on their own website, of course with the consent of those who'd written them. So it was possible to make some kind of a judgment, and overwhelmingly they rejected amendments to the Act. But the freedom debate has now been turned completely on its head, and we're faced with an entirely different balancing act around the proposed anti-terrorism legislation. These new laws are to be introduced to respond to a terrorist threat that it is feared may be posed by Australians returning from fighting in the conflicts in Syria and Iraq. It's now proposed that to advocate the promotion of terrorism will be a new offence. ASIO officers of one form or another will be immune from civil and criminal prosecution, except for the most egregious acts, such as murder. Retention of metadata will be required for 2 years. The burden of proof may be shifted to an accused to demonstrate why they've been in conflict zones. Search warrants over our computer networks can be issued for 2 years by the Director General without judicial oversight, and passports can be suspended. Seemingly overnight, there's been a radical reversal of the public debate, from protection of the right to freedom of speech in a democratic multicultural society to introduction of a suite of proposals to limit that right, among many others, in the interests of national security. My point is not, for the moment, to debate the merits of either of these policies, but rather to observe that we do not have a normative, culturally endorsed support for fundamental human rights in Australia, and that is why the compass needle can swing so wildly from seeing the value of protecting human rights to reducing the protections of fundamental freedoms. And it's appropriate when considering our contemporary environment in Australia to remember that next year is the 800th anniversary of the Magna Carta, signed very reluctantly by King John at the demand of his rebellious barons in 1215. Buried in the middle of this foundational document of English constitutional law, setting out the single measure for wine and ale and the rights of widows at the deaths of their husbands, are these words: "No freeman is to be taken or imprisoned or disseized of his liberties, or in any way ruined, save by the lawful judgment of his peers, or by the law of the land. To no one will we deny or sell or delay right or justice." The right not to be detained arbitrarily is an ancient and fundamental human freedom that's recognised in every common and civil law system in the world. Yet today, in Australia, we are eroding that right by conceding a detention power to the executive that's often not subject to effective judicial review. It remains true that Australia's limited approach to human rights has been largely effective in ensuring an environment that protects most human rights, at least in recent history. Australia has been a good international citizen for the most part, and has been a leading nation in negotiating the body of international human rights treaties developed over the last 50 years, most notably, of course, through the work of Doc Evatt as the key driver of the Universal Declaration of Human Rights in 1948, and who was president of the United Nations General Assembly at the time of its adoption without a dissenting vote. It was a remarkable achievement by a man who was Australia's representative leading the General Assembly at a time when Australia was barely recognised as an international player. But his sheer force of personality in working also, of course, with Eleanor Roosevelt achieved this foundational document, which then formed the basis for almost all current international human rights treaties. And you'll be familiar with them, but I will briefly list them: the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, Convention on the Rights of the Child, the Convention on the Elimination of Discrimination Against Women, Convention on the Rights of Persons with Disabilities, the Convention on the Elimination of Racial Discrimination, and the Convention Against Torture are the typically named 7. And Australia is a party to all of these. However, there's a fatal flaw. These recognised principles of human rights law do not become part of our domestic law without the passage of appropriate legislation. And most of these treaties are not part of our domestic law. In fact, the exceptions of the ones that I've mentioned are on sex discrimination, disability discrimination and racial discrimination. The other treaties are not part of our Australian law. Not only are the human rights treaties not part of our law, but core human rights principles, whether developed at common law or international law, are liable to be trumped by unambiguous legislation, reflecting, of course, the supremacy of Parliament. Relative to comparable common and civil law systems, we have very few constitutional or legislative protections for fundamental freedoms. Even worse, I'm reliably informed, with very little education in school about basic rights. And I'm also reliably informed that when surveys have been conducted, 90% of those asked if we have a constitution will say no, and 60% of those asked if we have a Bill of Rights will say yes. Well, neither majority answer is correct. Indeed, we seem to know more about constitutional rights from American television programs than we do from our own educational curriculum in schools. I understand that a man recently convicted of murdering his wife on indisputable evidence asked the police on his arrest if he could plead the Fifth Amendment. It's fair to say that the philosophical approach to human rights, derived largely from so-called classical liberalism, reflects an Anglo-Australian reluctance to recognise positive rights. Rather, we emphasise the rights to individual freedom from government and executive action, rather than positive rights to personal action. Indeed, as Williams and Hume have pointed out, the Australian Constitution was not generally intended to protect individual interests such as autonomy and personal dignity. Not only does Australia have few constitutional rights, and I think you'll be aware of those, the right to freedom of religion, the right to vote, the right to compensation if your property is expropriated, and an implied right to political communication, which reflects in the High Court's view that we have a right of, we must have a right of political communication if we're to be engaged in representative democracy and vote in an informed way for Parliament. So we have those few constitutional rights, but we also, as you well know, have no Commonwealth Bill or Charter of Rights, legislative or entrenched, unlike all other common law countries, such as the United Kingdom, New Zealand, Canada, and South Africa. Each of those countries views their own laws through the prism of their human rights legislation. And indeed, when one works in Europe, you will find that all conversation about rights is viewed through their European Convention on Human Rights and, of course, their domestic legislation. But Australians speak almost a different language because we simply don't view our laws through this prism. But in addition to that position, we have no regional court like the European Court of Human Rights, or similar courts in Latin America, Africa, and now more recently in the Arab countries. We are, I believe, increasingly drifting away from the evolving jurisprudence and legal systems with which we have the most in common. In the absence of many of the fundamental freedoms protected by legislation and judicial procedures, it can be very hard to find, in practice, a legal hook on which to hang an argument before a court to challenge laws on the grounds that they violate fundamental human rights. Now, I should, and I did concede a little earlier, that of course in practice Australia does meet high standards of human rights compliance for the most part, and it has a well-deserved reputation as a good international citizen. So how do we achieve it? Well, in practice we do it through a combination of factors. One is a culture that builds on and demands fundamental freedoms, the insistence on a fair go, tolerance and equality of opportunity. If you ask the woman in the Pitt Street Mall or the Bourke Street Mall if she's got a right to freedom of speech, she'll tell you pretty quickly that of course she does. But if you ask her what the basis for that understanding is, she really won't be able to tell you, and frankly won't much care. The importance of human rights, as we know, does depend on the cultural normative expectation that these rights will be met. We have some legislation, and I've mentioned in race, sex, anti-discrimination on disabilities. We have charters of rights in Victoria, as you well know, and the ACT. We also have judicially developed common law principles of legality and statutory interpretation. And New South Wales former Chief Justice Jim Spiegelman has made a fairly coherent argument that the principles of statutory interpretation, broadly speaking, that Parliament does not intend to enact laws which breach fundamental freedoms, constitutes a form of mini Bill of Rights. Many of you will remember, of course, from law school that substantive rights emerge from the interstices of procedure, and there's a lot of truth in that. We also have a Joint Parliamentary Committee on Human Rights that scrutinises bills for human rights compliance and compatibility. We have principles of administrative law, such as the rights to due process and natural justice, and we have the monitoring and complaints functions of the Australian Human Rights Commission. This mixed regime has been relatively effective in creating an environment in which Australians will assert their right to fundamental freedoms. But the practical reality is that unambiguous legislation will be applied by the courts even in the face of a breach of human rights or of common law principles of liberty. Well, in thinking about this topic and wanting to talk to you about 3 specific cases, I was reminded, thinking nostalgically about coming back to the University of Melbourne, about the sort of thing we learned in legal history in first-year law here at the law school. And I was reminded of the fascinating struggle between government and parliament on the one hand, and the federal and high court on the other. Or thinking about that, I was reminded of the epic battle that we understood between King James I of England and Sir Edward Coke in the early 17th century. And perhaps we might get a picture of him. We've had a picture of Scott Morrison, but there he is, Sir Edward Coke. He was the Chief Justice of the Court of Common Pleas, and he was also Chief Justice of the Court of King's Bench. And it was in these roles that he earned the fury of the king by declaring that the common law was the supreme law of the land, and the king could not change it. The common law was supreme even above royal demands that his courts should not interfere with the king's grants of several ecclesiastical offices to one person alone. Coke would submit only to the will of Parliament, and he introduced a Bill of Liberties to Parliament in 1628 against the use of royal prerogatives, relying in part on the Magna Carta, and presented it to King Charles I as a petition of right. Well, I don't suggest that Sir Edward Coke was a paragon of virtue for human rights. In delving a little more into his history, I understood that when he was in a particularly bad position with the king, he hoped to bolster his political position by kidnapping and marrying off his 14-year-old daughter to a brother of the Duke of Buckingham. Well, apparently that did reinvigorate his political powers, and he went on, of course, to great acclaim within the court system. But it was a very interesting battle over the supremacy of the common law above executive power. And it was with that in mind that I've been looking at some of the recent decisions of the High Court of Australia. And one that illustrates the way this process of human rights can apply, in a broad sense, is the Malaysia Solution. These are all known by particular plaintiff numbers, but it's the plaintiff M70 case from 2011. But this was a case where the Australian government had announced in early 2011 that it had agreed an arrangement between the government of Australia and the government of Malaysia on transfer and resettlement, whereby up to 800 asylum seekers who arrived in Australia by boat would be removed to Malaysia for processing of their claims for protection. Under the arrangement, the Australian government agreed to accept 4,000 recognised refugees from Malaysia for resettlement in Australia. Well, 2 asylum seekers who were vulnerable to this transfer process challenged the validity of that transfer. Under the legislation, the Migration Act, Section 198A, the Minister for Immigration was required to declare that Malaysia was essentially a safe country to send refugees. The legislation specifically provided that the Minister can declare a country to be a safe country if it provides effective procedures for assessing refugee claims, provides people protection for seeking refugee status, provides protection to those who've been granted refugee status, and meets relevant human rights standards. The Minister made a declaration that Malaysia met each of these criterion, and that the country was a country in which refugees could be resettled. the High Court of Australia took a different view. It said that as Malaysia was not a party to the Refugee Convention or to its protocol, and there was no other basis on which any reasonable assurance could be made that effective procedures will be available for refugee claim assessment or for protecting refugees once assessed, that therefore the declaration was beyond power. And on that technical basis of statutory interpretation, it was found that in effect, the Malaysia Solution was unworkable and it was not proceeded with by the government. But here is perhaps the critical point that I want to make, that in light of that finding by the High Court by an interpretation of the terms of the Migration Act itself, the government went straight back to Parliament and deleted the clause so that it was no longer available for any subsequent arrangement. Now, we don't know whether the Cambodian proposal will take place, but in relation to that proposal, there will be no such limiting provision in the Migration Act to qualify the declaration, if it happens, that Cambodia is an appropriate place to send asylum seekers. But the second case I wanted to discuss is the case of Al-Khatib in 2004. This was a case that concerned a young Palestinian seeking asylum in Australia. He was born in Kuwait, but he was legally stateless and no country would accept him. The Australian government held him in detention indefinitely. When his lawyers challenged his detention in the High Court, a majority of judges decided that the Migration Act gave the Immigration Minister the power to detain an unlawful non-citizen until he or she is removed from Australia. So a power in the Act itself to detain an unlawful non-citizen until he or she is removed from Australia. The point then was that the minister continued to hold Al-Khatib for 4.5 years or more, and more in relation to others, on the grounds that as no other country would accept them as they were stateless, there was the power to detain them forever, indefinitely. Now, this is somebody who'd been charged with no offence, who'd had no day in court, no ability to have any charge laid against him, and it is not, by the way, a criminal offence to enter Australia without a visa. So the question for the court was, is that interpretation of the power one that is valid under Australian law? Well, the majority found that mandatory detention was not punitive and therefore not a breach of Chapter 3 of the Constitution with respect to judicial power, and that there is a power of the executive to hold persons for administrative immigration purposes. So had it been punitive, it would have come within the judicial power under the Constitution. But the majority said it is not punitive to hold somebody without charge or trial for 4.5 years with no end, so long as the government had a general aim of deporting him when they could. Now, given that there was no reasonable prospect of ever being able to deport him, it was an extraordinary conclusion. The majority then said that the language of the Migration Act was absolutely crystal clear. You could hold the unlawful non-citizen forever, if necessary, and they could not be removed. Well, the minority judges took an entirely different approach to interpretation. The Chief Justice, Murray Gleeson, said that the Act should not be interpreted to permit indefinite detention. Justice Gummow chose to read the power down and said if it's not capable of being carried out, if you can't deport for practical purposes, then you read the power down and release the asylum seeker. Justice Michael Kirby, who I understand has given an earlier lecture, you won't at all be surprised to know, he didn't emphasise the principles of statutory interpretation, but rather the broad presumption in favour of liberty. And he said that presumption should prevail. Interesting, the Justice McHugh, with whom he had a great battle in their respective judgments, said the continued outcome in detention for Al-Khatib was tragic. But he suggested that the remedy lay in adopting a Bill of Rights for Australia. And he said, as long as the detention is for the purpose of deportation or preventing aliens from entering Australia, the justice or wisdom of the course taken by the Parliament is not examinable in this or any other domestic court. It's not for courts exercising federal jurisdiction to determine whether the course taken by Parliament is unjust or contrary to basic human rights. Which is, I believe, a quite extraordinary statement, that the courts have no power to consider whether a course taken by Parliament is unjust or contrary to human rights. Well, the last case that I wanted to mention is one that was decided, I think, just 3 days ago, the S4 case against the Minister for Immigration. This was a case in which the High Court of Australia appears to have reasserted the fundamental right not to be detained arbitrarily. In a strong and unanimous judgment, the court found that the Migration Act does not authorise the detention of an asylum seeker at the unconstrained discretion of the government. Rather, an alien, whether in Australia lawfully or not, is not an outlaw and cannot be detained other than in accordance with the law. The court concluded that the temporary visas granted to the plaintiff were not granted in accordance with the law and were therefore invalid. Well, the decision provides an illustration of how complex the Migration Act has become and of the quiet determination of the High Court today to ensure that the rule of law applies to asylum seekers. The plaintiff's story is quite typical. He arrived by boat on Christmas Island, stateless and without a visa. He was detained for more than 2 years under the Migration Act, and as an unlawful non-citizen, he is barred from making an application for a protection visa, unless the minister chooses to lift the bar. Well, typically, of course, the minister does not exercise that discretion to lift the bar, so the upshot is that, again, an asylum seeker can be detained, apparently indefinitely, or at least until this decision. It's interesting, though, that in this case, the plaintiff was found by the Department of Immigration to have, or to meet, all the legal requirements for a refugee and to have met the health and character criteria for making a visa application. But it's at this stage that the case became atypical. The minister decided to consider whether to allow the plaintiff to make an application for a permanent visa. But instead of making the decision, the minister chose to grant the plaintiff 2 visas on essentially humanitarian grounds, one for 7 days, he'd been in detention for more than 2 years, but the other, a temporary one, for 3 years. But here is the catch. Each of these visas would prevent the plaintiff from making any future application for a permanent visa. It was agreed, both by the government and of course the plaintiff's lawyers, that the minister's clear objective when granting the short-term visas was precisely to prevent the application for a longer-term one. So the legal issue for the court was whether the minister could validly grant the limited visas if the practical effect was to prevent the plaintiff from applying for a permanent one. The problem lay with the bar to applying, not with the fact of the temporary visa. Well, the High Court unanimously found that the plaintiff's prolonged detention served no purpose under the Migration Act if the minister grants a visa that forecloses the exercise of his power to decide that an application for a protection visa could be made. Now, this case is, again, a technical exercise in statutory interpretation. But this time, the court took the opportunity to clarify the law. It found that an alien may be detained lawfully under the Migration Act if it's reasonably necessary, either for his deportation, purpose number 1, or purpose number 2, to enable an application to be made for permission to remain in Australia. But, and this is the critical point, a non-citizen can be detained only for a valid statutory purpose, not at the executive discretion of the government. Of vital importance to the rights of asylum seekers, often detained for years for one reason or another, is the court's finding that the decision whether the plaintiff could apply for a visa must be carried into effect as soon as is reasonably practicable. In short, detention is not at the discretion of the government, but that detention must comply with the terms of the Migration Act. What is reasonably practical remains to be seen on the facts of each case, but the minister is now on notice that in future courts may require speedier decision-making that does not leave asylum seekers in mandatory detention for unreasonable periods of time. It might be thought that to detain a person for over 2 years who meets the legal definition of a refugee without deciding whether he can apply for a protection visa would fail that test. But another and rather tantalising aspect of the court's judgment was its recognition that, to quote the court, the large question of the right to liberty, if threatened by an invalid decision-making process, remains unresolved. It's open to the court to consider applying the constitutional writs such as mandamus to compel a minister to respect the right to liberty in an appropriate case in the future. For Plaintiff S4, the outcome of the decision may not be encouraging. He's back to square one in the sense that he may continue to be detained pending his deportation, which we know is highly unlikely because he's stateless, or pending a decision to allow him to apply for a visa. The ray of light is that any such decision must be made promptly. The time-honoured principle enshrined in the Magna Carta remains alive within the Australian common law to prevent arbitrary detention under the guise of executive detention and to apply the rule of law. So we've come through an interesting journey, and I've only mentioned three of a dozen or so really interesting cases in which the High Court has done what it can by interpreting both the Constitution and the terms of the Migration Act. But more recent jurisprudence, I think, suggests quite to the contrary of Justice McHugh's view that Parliament cannot look at whether or not, that the courts cannot look at whether Parliament has been unjust or whether it has acted contrary to human rights. There is now, I think, an emphasis in the High Court to ask whether the legislative measure is necessary and proportionate to meet a legitimate outcome. And the notion of proportionality is becoming a larger one in the way in which the courts seem prepared to look at questions of fundamental human rights. And they have used that in other cases, including the Monas case, a very interesting case in which two men were charged with sending letters through the post, causing offence and harassment to the families of Australians killed in the Afghan war. They had sent letters that the court said were demeaning and threatening and abusive to the parents as a political statement, so their attorneys argued, or lawyers argued, as an exercise of a political freedom of expression to object to the war in Afghanistan. The question was whether or not, in that case, the letters were offensive under the terms of the Postal Code. Often these things come up in quite banal contexts. And the question for the court was whether or not this was a necessary and proportionate law related to a legitimate outcome. The court split 6-6. Unfortunately, it was only 6 members of the court, and as luck would have it, of course, it was split. But the upshot was that 3 members of the court approved the lower court ruling that to send letters through the post in this way with a deliberate attempt to offend and insult was a law that was valid, was necessary and proportionate. Those were the 3 women members of the High Court, which gives us a little bit of a sense, perhaps, of how some of these principles of proportionality and legitimacy are going to be played out. But now, in a few minutes, because I don't want to go too much over time, I'd like to tell you a little bit about the inquiry into children in detention. I have yet to report, and so I can't, of course, tell you about the findings and recommendations, but I can tell you a little bit about why we call the inquiry specifically and how we've done it. Now, the Commission has a very significant power, and I as President have that power, and that is that I can call an inquiry into any matter concerning the acts and practices of the Commonwealth under our legislation. Now, it's a power that we use, any President has used very carefully, but we used it more than 10 years ago for an inquiry into children in detention, then in Nauru Mark I, if you like, that led to a report called The Last Resort, dependent, of course, or reflecting, of course, the key provision that children may be detained under the Convention on the Rights of the Child only as a last resort. That inquiry was successful in that within weeks and a very few months, under the Howard government, all the children were released from detention. My predecessor, the Honourable Catherine Branson, and from the Federal Court, also called an inquiry into the use of wrist x-rays to determine the age of children, whether they were 18 or not. And that was a particularly successful exercise in the sense that she worked very collaboratively with the government, and they agreed, even before she'd reported, that using wrist x-rays was scientifically not valid, it was an inappropriate way of determining the age of children, and new methods were being developed by the Australian government. So it was a collaborative, sensible use of the inquiry power, and it achieved an outcome. By July last year, it became very clear that not only did we have significant numbers of asylum seekers arriving in Australia, indeed an influx, to use the language of the United Nations High Commissioner for Refugees, and large numbers of children were being detained under the mandatory detention policy that had been in effect in Australia under the Migration Act since 1994. And the government chose to exercise that mandatory detention obligation, and by July, something like 1,700 children with their families had been detained in closed detention in Australia or on Christmas Island. And the numbers then started to increase as more boats came and as the offshore processing began under the former government. The context in which this takes place is that UNHCR has reported that there are over 50 million displaced persons, that is, persons displaced within their own state, and asylum seekers and refugees in the international community globally at the moment. The numbers are absolutely unprecedented, at least since these numbers have been recorded. And of the 11 million asylum seekers of direct knowledge to the UNHCR, Australia receives 1.4 to 2% of them. We are a top receiving country through the processes of UNHCR of about 21 states, but that's only about 1% of those seeking asylum. There is no queue, and there's no possibility of travelling to consular or diplomatic offices to fill out forms. We currently have 6,000 asylum seekers with their children detained in facilities in Australia, Christmas Island, Nauru and Papua New Guinea, and currently 700 children are detained. 183 on Nauru, 157 on Christmas Island, and the balance in Australia itself. And we also have 33,000 asylum seekers in Australia, both in closed detention and in the community on bridging visas with no work rights, who await assessment of their refugee status. That, of course, is a particularly cruel situation in which the one thing they have to cling on to is their right, in their eyes, to be judged as refugees. And we know that 85 to 90% of them, if assessed, will be assessed as refugees. But to take away that assessment right is particularly demoralising for those people. Well, the legal principles are really very straightforward. There is a right at customary international law through the Universal Declaration on Human Rights to claim and enjoy asylum. There is a right of refugees to protection of the state and not to be returned, the principle of non-refoulement. There is a principle of non-discrimination and a principle that no penalties may be adopted for unlawful entry. There is a right to freedom of movement and, of course, the right not to be detained arbitrarily and, of course, the right of a child and the best interests of that child to be a primary consideration. Well, as the numbers rose, I became increasingly concerned about the matter and realised that we were going to have another inquiry. But I also realised that we were in an election year and we were moving straight into a caretaker government, and it was best to wait until we saw if there was going to be a change of government and possibly a change in policy. And that is why we waited until February, 6 months into the new government, to see what, if any, changes they were going to embark upon. In fairness, of course, the Minister did release about 1,000 children and their families into the community in either community detention or on bridging visas. And that has left now, as I say, about 700 children detained. But what was increasingly worrying by February was that the length of time for which the children and their families were being detained was double, and it's now increasing, of course, by the day. So not only were they being detained for long periods of time in particularly harsh situations, but their claim to refugee status is not being assessed. So they're in a legal twilight zone or black hole where they really have no capacity to change their position in any way at all, and for practical purposes, virtually no capacity to get before the courts. And that is why the decision in S4 that I've just talked to you about is so important. Because if the High Court is clear as it now is in saying you may detain only for the purposes of deporting, and if they're refugees they can't be returned, or you can detain them for the purposes of considering giving them a right to apply for a visa. But you cannot hold them indefinitely, taking no action in relation to either. So the decision is a pretty monumental one, because it means that the High Court has required the Minister to make a decision within a practical period of time. Now, what that period of time is, as I say, I really don't know, but I think it's got to be less than 2 years. Many asylum seekers have been held for many years, and of course those already adjudged as refugees with negative ASIO assessments, not subject to public scrutiny of any kind, they have no access to the courts, and they are specifically barred from raising habeas corpus or any other writ before the courts. So we decided to go ahead with it, and the methodology has been extremely important, because we must get our facts right. The law is not so difficult to get right, but the facts are. We have had 5 public hearings. We've had about 45 witnesses, 1 or 2 compellable, because they were concerned that if they voluntarily gave evidence to the Commission, they would suffer with their former employees. But in the main, people gave evidence voluntarily, including the current Minister and the former Minister, Chris Bowen. I've been to every detention centre where children are being detained, and Christmas Island 3 times for quite significant periods of time. We've received now well over 300 submissions from the public, and we have conducted interviews with 500 families covering about 1,500 asylum seekers to get their views of their conditions. And we've got a lot of evidence from the International Health Services and groups like Save the Children, who are working on Nauru and Manus, on Christmas Island and Nauru. So it's been quite extensive, but a very important part of the methodology has been, one, to get evidence that is subject to critical analysis. It can withstand, we hope, concerns about methodology, accuracy, or bias. But most importantly, on each of the visits to the detention centres, I've taken with me a child psychiatrist and a paediatrician, and others with expertise in the field. So when Elizabeth Elliott, for example, a very well-regarded paediatrician, says that almost every child on Christmas Island is sick, it is a professional judgment that is in fact backed by her own professional association in Australia. We're getting groups now starting to speak out, groups that typically don't want to engage in the political and legal environment, but we've now found that church groups, religious groups are now coming out with their own views and indeed their own evidence. We hope in time for us to report in the next few weeks. So that's been the methodology. We hope that we will be able to make balanced and evidence-based proposals, and I sincerely hope that we will find that the department and the government give some credence and take some notice of what we're saying. But that then leads me to make, just to conclude, and that is to say that Australia does implement human rights in multifaceted ways. We use the institutions of modern democracy, Parliament, the courts, administrative law, and human rights commissions to ensure a normative culture in which human rights are for the most part respected. But the ad hoc approach to human rights protection is not sufficient, as many human rights and freedoms do not have formal recognition under the law. The need for a legislative bill or charter of rights is now, I think, a national imperative to protect against the growing encroachment of executive discretion that's frequently not subject to scrutiny, particularly in the context of the new anti-terrorism laws, some of which we've seen and others of which will be arriving over the next few weeks. I believe it's time to reopen the public debate about the legislated form of a human rights charter, to ensure that all freedoms are better protected, and that where freedom is limited, we're in agreement about the principles by which to determine that limits are fair, proportionate and reasonable. I'm of course well aware of the national consultation process conducted by Father Frank Brennan, and that it failed to attract the necessary political will to support his recommendation for a Charter of Rights. But I do not believe we should give up on the need for an effective human rights mechanism. I was somewhat dismayed to see that the Prime Minister, in considering whether an anti-race discrimination clause should be included in any constitutional amendment to recognise our First Nations peoples, said he did not want a racial discrimination clause because that would amount to a mini Bill of Rights. Now, not making a comment one way or the other about the value of a clause of that kind in the Constitution. What concerns me is that the Prime Minister is able confidently to say that anything that amounts to a Bill of Rights or a mini Bill of Rights must necessarily fail. He may be right. He's a much better judge of political outcomes than I am. But it says a great deal about the body politic that you can dismiss something as viable simply by saying that it constitutes a mini Bill of Rights. But as I say, I don't think we should give up. I believe that we should all have an obligation to speak truth to power, to be clear about the facts, to understand the law, and to demand that Australia meets its international obligations and indeed its common law fundamental rights. I believe that as a nation, we need to respect all human rights and freedoms in our multicultural society, and indeed I think at the moment we need especially to remember those rights in a way that promotes social cohesion and inclusion for all. As a nation, we need to, and I believe we can, do a great deal better. Thank you very much.
Thank you, Professor Triggs, for a very stimulating and engaging lecture. Now we're going to have about 10 minutes for some questions, and we have a roving mic. And while you're collecting your thoughts, let's maybe make one whimsical observation. In my role as Professor, as Pro-Vice Chancellor Engagement, I've actually taken to social media over the last 2 months, and I've learned something tonight. It's rather hard to communicate complex legal ideas on Twitter. By the time you say Gillian, Triggs, jurisprudence and exceptionalism, you've run out of space. So, do we have any lectures for any questions for Professor? Just here.
Hello, thank you very much for a very, very interesting lecture. My question is just about some of the figures that you mentioned, the alarming numbers of children that are held in mandatory detention for such long periods of time, and I just wonder why that kind of information isn't just more readily available. If people were actually more aware of those kind of figures, then perhaps public opinion would be swayed.
Yes, all of the figures that I've cited to you are on the departmental website. But I have a team of about 20 people, 2 or 3 of whom keep an eye on that website all the time. They've had to work very, very hard to dig the facts out of it, because what they do is list the numbers under all sorts of language of alternative places of detention or closed community detention or whatever it is, under all sorts of it's broken down and fragmented, and you have to go through each segment, pick up the number, and to ultimately develop it. And so one of the interesting things when we interviewed and spoke to the current minister and the secretary of the department, we knew the figures far better than they did. And on one occasion, we asked how many babies had been born at Christmas Island, and we were told that they couldn't tell us because they didn't have the biodata. Now, I'm not sure why you need biodata to work out if you've got a baby on Christmas Island, but that was the sort of response that I'm afraid you're going to get from the department. And so one of the things we're doing on our website is getting these figures up. But it's not hard, not easy rather, to engage the public in the sheer numbers. And when I do a lecture of this kind, or speak, depending on the audience, of course, I don't usually speak to an audience by going through the decisions of the High Court of Australia, I promise you. It's just in this company I knew I could. But normally, of course, I do speak a lot more about these conditions and about the numbers. And people say to me again and again they had absolutely no idea that so many children were detained, with their families, of course, but I mean, although some are unaccompanied minors. But I think it's shocking for Australians to realise that. And I think in a way, perhaps the tide is turning a little. But the reason I wanted to produce that slide of the current minister as Russell Crowe was to give you some sense of the environment, at least in Sydney, where people are so resistant to understanding what the consequences of those figures are in human terms. To say nothing, of course, I haven't spoken at all about what the international law says about stopping the boats. Turning back the boats of people who are seeking the protection of Australia as asylum seekers is clearly in breach of international law. And the UNHCR and the United Nations Human Rights Committees have been saying this for a very long time. And then we've just had the incoming High Commissioner for Human Rights making the same comment and saying that our detention policies constitute arbitrary detention and, to use his language, possibly torture, which is, of course, what the Human Rights Committee had decided some 2 months before. So those are the ramifications, but they're the problems of not being able to get this engagement of the Australian public on these issues. But I generalise because I do go to a lot of country areas. I was in Bathurst last Friday night, and I think about 400 people came to a lecture coming from Orange and various places into Bathurst, all interested in asylum seeker policy, really fascinated and eager to write to their backbenchers and to talk about, why this is happening. But I think it's taking time for us to wake up a bit. And I also think that there's this language of war and victory linked to, I'm afraid, anti-terrorist activities and raids, and a sense of fear has sort of concertinaed the issues in the public mind, and we need the public leadership to be able to say, we can separate these matters and we can deal with them in a humane and legally effective way.
Thanks very much, Gillian, for a very thought-provoking
Oh,
lecture.
Alison, yes. Hello.
Hi. You spoke a lot about some of the High Court judgments, about the parliamentary laws and about the executive, the role of the minister. I wonder if you could just speak a little bit more broadly about the way you see the Human Rights Commission fitting into those structures. I mean, I know where it fits legally, but I wonder where you see its power straddling across those different structures.
Yes. Well, thank you. That's a terrific question, because that is, in a way, our problem. We have a very interesting legislation that gives us power and requires us to hold the government to account to comply with international human rights law. And that human rights law is defined by that list of treaties I gave you. The International Covenant on Civil and Political Rights, not economic and social, that's not in our mandate, but civil and political rights, which is, of course, all the core fundamental human rights emerging, or most of them, from the Universal Declaration. Convention on the Rights of the Child, not part of Australian law, but part of our mandate. Torture, refugees, disability, race and sex. Now, the ones that are our measure of human rights is the international treaties, only 3 of which have been given direct implementation in Australian law. So when to put this very simply, when I go to see the minister and so I say, what you are doing clearly breaches public international law, he says, but not Australian law, but not the Migration Act. If through our lawyers we go to the court, we intervene in many of these High Court cases, I might add, at the discretion of the court, but they have always permitted us to intervene. And indeed, some courts will actually positively request us to intervene, for a very interesting reason, actually. In an adversarial common law system, you have one party putting an adversarial position on one side and another party putting it on the other, whereas we're putting what we believe is an objective position in the middle, which can sometimes help the court, and they very often do cite our work, because it's not produced to the court by either party. Which is quite interesting. But the core point I want to make is that if we do intervene in the court and we put our legal arguments, not infrequently, the court will say that's very interesting from a comparative point of view or understanding international jurisprudence. The European Court of Human Rights, the practice of the New Zealand courts or the Canadian courts. But most judges will say that's not anything more than comparative interest. It cannot be binding on Australia or on the courts without implementing legislation. And the reason for that is the supremacy of Parliament. To go back to Sir Edward Cook's view, which of course very much set the scene of the power of Parliament. But in fact, it gives Parliament, at least when you look at it in the Alcatel kind of case, it gives Parliament an enormous power. Because the courts have very little room to move if the legislation is unambiguous. If the legislation is ambiguous, the courts have got the opportunity to use all their common law principles of statutory interpretation. And the rather ironic phenomenon is that with the anti-terrorism legislation that we're looking at in a great deal of detail at the moment, the greater the overreach, the more ambiguous, as some of these terms are. It applies to computers connected to a network. Now, most of you will know that computers are connected to a network. It's every computer. It's all got to be redefined. If it's broad, ambiguous, an example of overreach, the courts have got a chance to read it down and to apply common law principles of legality. Where that legislation will go, of course, we don't know. It's got to go through committee processes and through the Senate, so Lord knows what's going to happen to it. But to come back to your question, Alison, the problem for us in the Commission is that our mandate is international human rights law and the treaties, and in 3 instances legislation, with a 4th being, in fact, the age discrimination legislation that Susan Ryan administers, which is not reflected in an international convention. So that's a sort of an odd one. But we also have a mandate, most importantly, in broad human rights defined by international treaties that are not, for the most part of Australian law. So it's a very strange position to be in. But it doesn't deter us because we sort of keep pushing the arguments, but we know we will hit a brick wall on occasion when the minister says, I'm acting entirely consistently with Australian law. The Migration Act says that there's a mandatory detention of asylum seekers and I can hold them for as long as I like, at least until the S4 case, which qualifies it. So it is a curious position to be in, but we also have a role of advocacy. And I'd say that the 6 commissioners of the Human Rights Commission, that is their primary job, advocacy. So that Liz Broderick in gender, sex, Tim Sook-Parmesan, originally from Melbourne, you probably know of his work in race discrimination. Mick Gooder, I've mentioned, in Indigenous social justice. Megan Mitchell as the first Children's Commissioner. Susan Ryan now does both age and disability, and Tim Wilson, who has been appointed as a broader Human Rights Commissioner, and he has taken on responsibility for sexual orientation and for freedom of speech, but that's sort of gone a little bit in the background now that 18C is not going to be amended, and he's now working with me on the anti-terrorism law. So that they play predominantly an advocacy role, and we also have a section of the Commission that works on education. So one of the things, teachers are always overstressed, they've never got the materials, and one of the things we're doing is building modules for teaching purposes so that teachers can get core human rights into the curriculum. Now, it's controversial, I'm sure you know it's very controversial. You put the tag of human rights on something for a teacher to teach, and there are a lot of people who'll object to it. So we are actually finding other language. One of them, for example, is working with maths, trying to work with students on how to do proper methodologies for questionnaires that might explore rights to freedoms. But I find, as with our work with China, we have bilateral work with China and Vietnam, Indonesia, Myanmar, and of course through the United Nations itself, we're an A-class national human rights body. I tend to be extremely practical, and if you can work with China effectively on violence against women, I'm perhaps not going to push the line that they should have freedom of speech in Tiananmen Square. I tend to do what you can actually do as a practical matter. So that just gives you a little bit of a picture of the range of work that the Commission does, and it's certainly a huge privilege for me and absolutely fascinating to work with about 135 people on these issues. And I think that it's education, advocacy, our complaints mechanism. As I say, we have 20,000 inquiries and complaints a year. We settle 70% of them, but you cannot go and this is perhaps a lawyer's point, but you cannot go to the federal court unless you come to the Commission first. But we're free of charge. Either parties can put their position without any fees whatsoever at all. And so I think it's one of the most important means of access to justice that's available in Australia for most Australians. And more importantly, perhaps through that conciliation process of complaints, we can usually work, because most of the complaints arise in the employment context or in the delivery of goods and services. We work with the employers or the persons delivering those services, the companies typically, and they're usually not happy to know that they've been called up on a failure to comply with international law or discrimination law, and they will usually go back and work with us on systemic change. So you can achieve a lot more than just solving the problems with the 20,000 or so people that come to us. So I think it's a very powerful mechanism for cultural change, for education and for advocacy, but it's severely limited by the problem that Alison's, I think, aware of, and that is that our mandate is the international, not the domestic, with exceptions.
We're a little over time, but with your indulgence, I'd just like to... I have a question on promise over on the side, and then we can just keep it quick.
Julian, I just was curious as whether you could comment the recent decision about the government not having the ability to detain someone indefinitely without a reasonable, proportionate timeframe, etc., seems to be an about face compared to the previous High Court decision in this issue. Can you make a comment as to why this is happening? Is it a change in the makeup of the High Court itself or jurisprudence in general?
I think it does reflect a change in the makeup of the court. I'm not a constitutional lawyer. I really am in the international sphere, so I'm a little bit out of my crease in talking about the court in any real detail. But I believe that it does reflect a change in the constitution of the court. But I also think there's a jurisprudential change that takes the view that laws must be necessary and proportionate to achieve a legitimate end. And that, frankly, I learned at law school across the road more than 45 years ago. There's nothing new about that principle. But I think some judges could take the view that if a law was consistent with the constitutional power, like a law in relation to aliens, judges like Justice McHugh would say, and Justice Hayne for that matter, would say, so long as it is a law with regard to aliens, we're not going to inquire into whether it's fair or just. And there were a number of judges who would be prepared to take that view, that you couldn't interfere. So long as it met the language of the constitutional power, you wouldn't look behind it. But I think judges now are more inclined to take the view of the then Chief Justice. Of course, it's very, very powerful to have a Chief Justice like Murray Gleeson in the minority. And his judgment is really important to read, along with Justice Gummow. And of course, it's always inspirational to read Michael Kirby's work, but I do know perfectly well as an international lawyer that most judges don't go that far. So the judges to read, to get a sense of where the court is going, or was going, in the minority at that time, are Murray Gleeson and Justice Gummow. But now we have a differently constituted court, a relatively new Chief Justice, and we have the three women members of the court, and that's why I mentioned the Moniz case, because their judgment was quite short, quite simple, and pretty easy for a lay person to read. And I think that's a bit of a new change from the past. The judgments I used to have to read as a law student went on for 300 pages. And they were dense. This particular judgment in the Moniz case was a very, very useful one, because it set the principle absolutely clearly that the validity of a piece of legislation depends in part on whether it's a necessary and proportionate response to achieve a legitimate aim. They said it was, and therefore the two defendants in this case, because it was a civil matter, were convicted of the offence. So that's a judgment worth reading. So I think that modern thinking is that simply because you've got a piece of legislation that pertains to aliens, for example, is not sufficient. The courts will say does it meet the necessary and proportionality test? Now, whether many of them are going to go forward to say, what about the right to liberty, I don't know, but in the S4 case, that was an extraordinary piece of the judgment. It was really a not so veiled suggestion to the government that if they continue with judgments that fail to meet the statutory requirements, then the court might be prepared to use the constitutional writs, including mandamus, which means that you can require the minister to act in accordance with the law, which would mean that the minister would have to make a decision as to whether an application for asylum seeker status can be made. And they put it in terms of the right to liberty, which echoes, of course, Michael Kirby's language from some years earlier. So there are a few PhDs in this, if there are some students here. These are great subjects to look at. Read those judgments and make up your own mind. As I say, I'm not actually a domestic lawyer, but I do read these cases because they're so vital to how we start to understand the way in which normative human rights can be applied. But you don't have to come at this via international law at all, although obviously I do, and I do because of our mandate under the statute. But you can come at it as a common lawyer. When I worked in London, the chair of my board was Lord Bingham, who was the senior law lord of the House of Lords as it then was. And he wrote a marvellous book called The Rule of Law, shortly, in fact, before he died. And he made the point that a lot of judges are much more comfortable with. They don't like really talking about international law treaties and jurisprudence. They'll look at it for comparative purposes, but they're not really very comfortable with it. They're much more comfortable with finding the principles of human rights in the common law. And that was very much Lord Bingham's approach, and I think it's an approach that most of our judges are much more comfortable with. I think the former Chief Justice Murray Gleeson was as well, which is why I've been trying to refer back to the Magna Carta and to some of the ancient cases that have been decided over the years, which have developed the common law principles. And indeed, international human rights law came from domestic law. Of course it did. So it's an osmotic relationship between the two. But I think it's a part of the failure of our education system that we don't know enough about how our principles of law, whether they're human rights law or otherwise, our young people don't understand it. Although I made a bit of a joke about the American Constitution and the Fifth Amendment, the truth is our young people don't have any idea about their civics. You might call it civics if you like, but constitutional law, maybe it's a bit highfalutin, but we could teach our young people about their roles as citizens, their rights and their responsibilities, much more than we do in the community. And that way I think we might get a more responsive community that says to the government, you must act in accordance with these common law principles and allow our courts to act in accordance with those principles as well.
Well, thank you. It's been a captivating evening, and I think actually we could go on for another hour or so, just judging on how people are responding, but we can't. So would you join me in thanking Professor Triggs for a fantastic...